It's a little piece of paradise in Taranaki. A breathtaking block of land by the sea.
Yeah, you can fit through.
But to Haumoana White and his whānau, it's simply home.
It's everything. It's all that we are. You know, it's we are the land is us.
Now, part of where he calls home could be taken from him by a Pākehā family who believe they own this land too.
Losing's not an option. Our feet, our bones are too far into this land. Our blood is here.
That piece of land, or any land that we belong to, has no price. It's priceless.
This is a story about two families with two seemingly legitimate claims to one piece of whenua.
And you've always considered this your land?
Well, we not only believed it, we worked it. We were on it.
You've always occupied it?
Always occupied it. The nearest we ever came to not farming it was when my wife had a stroke and became disabled, so we were limited to what we could do.
Haumoana had never questioned whether the land belonged to his whānau, but all that changed when a local landowner, Angela Potroz, turned up out of the blue.
Mrs. Potroz came to my door and said, I've got to get the stock off the property over there, that block over there, because she now owned it. And I said, since when? And she showed me this piece of paper.
How did you react to that news?
Really, really annoyed.
Shocked?
Shocked, yeah. And I said to her, well, I'll fight you till my dying day.
The seeds of this dispute were sown in the 1920s when Haumoana White's uncle Kereni Wetini decided to sell some of his land to a Pākehā farmer.
Well, by 1929, nothing had happened, so the 1926 sale and purchase agreement was rescinded for lack of completion.
In 1933, the deal was back on. According to court documents, a certificate of confirmation was issued by the Māori Land Court, confirming that the Pākehā farmer had paid the agreed price for the land. But the sale was pending some conditions, and the money stayed with the Māori Land Board. Despite not meeting those conditions, the farmer was still somehow able to on-sell the land. In time, it was sold again and again, from Pākehā buyer to Pākehā buyer, with the owners' names only ever changing on the memorandum of transfer. Their names never appeared on the actual land title. That stayed in Māori hands.
Very difficult to explain the whakapapa of what's happened from, 1926 right till now, that they'll even lose interest at about 1930.
This block of land next to Haumoana's house is part of the 36 hectares of Māori freehold land that's being disputed in Tongapuroto, a small settlement in North Taranaki. Haumoana's father and uncle were gifted blocks of land by their father, Te Oro. For years, both blocks have been part of the whānau papakainga. What's at stake now is losing half their land and their access to the beach.
It's sort of hard to comprehend how we're meant to feel. It's very mamai. I think that that's our responsibility to preserve what we have here that's been passed down.
In 2003, the Potroz family believed they bought the piece of land with a neighbouring block. Angela Potroz told RNZ it wasn't until 5 years later they discovered a problem.
When we went to sell it, to pay our debt off to the bank, that block, we couldn't sell it because it didn't have proper title. It had a memorandum of title, but it didn't have its proper title. So that land got left.
What Haumoana and his whānau didn't know was the Potroz family had gone to the Māori Land Court to get the land title in their name.
We had no notification from the Māori Land Court. As far as we were aware, it was still in Māori only, in Māori title.
When Haumoana found out, he successfully appealed for the case to be reheard so his whānau could represent their side of the story. Because in their eyes, the original land sale way back in 1933 was never completed. Russell Gibbs has been the whānau advocate in court for the last 3 years. He says he's alarmed by how this case has been handled.
The Māori Land Court have facilitated the loss of this land. In the Lynn's title, it was held in the name of the Māori owners. The Māori Land Court records, the last transaction on their records was a succession order that had been signed and sealed. And so at every level, Māori still owned that land.
Since the death of his uncle in 1943, Haumoana and his whānau believed the land was theirs. Their uncle had left it to them in his will. After 2 hearings and 2 appeals, the Māori Land Court ruled that the succession orders in 1945 were in error and the sale was valid. In the court's eyes, the land was already sold. It was no longer his uncle's to give away. So in 2014, the Māori Land Court determined ownership to the Potroz family.
If it sets a precedent, that puts in jeopardy every succession in this country. If you can go back 70 years, you can go back 100 years. You can go back to settlement if you want to. Be very afraid if the judges can do that.
Māori lawyer Dayle Takitimu agrees this case is complicated.
It's definitely confusing, there's no doubt about that. And I'm sure each of the respective parties would, consider their side of the tale legitimate.
What are the injustices here?
There's been some balls-ups in terms of the process. And that's, this is from way back. We're talking about, long time ago and little hiccups along the way. But it's the compounding nature of that you actually end up with a bit of a shambles and a bit of a jigsaw puzzle that doesn't quite have all the pieces to it in a legal sense.
And it gets even more interesting because this is Māori freehold land, now owned by Pākehā.
It is unusual. I wouldn't say this is the only case of it, but it is unusual, and in fact it's against the thrust or the ethos of the Act itself, which, big preamble in the Act is about the retention of Māori land as a taonga tuku iho, which is difficult, obviously, in any interpretive sense to say that Pākehā could hold Māori land as a taonga tuku iho.
Both Russell and Haumoana are convinced the original sale was never completed and say their uncle never received a penny for his whenua.
We thought it was all finished. It was all no money, no deal.
Is this modern day land confiscation?
Oh, I'm sure it's modern day land confiscation. The purpose of the ture whenua is supposed to be to retain Māori land, not dispose of it. And if you look at what the court's done in this process right from 2013, they have actively disposed of this land, not protected the Māori owners at all.
The whānau have taken things into their own hands, cementing their whānau links to the whenua by building a small wharenui on the land.
To an extent, it was to show that we're not going, but to our view, it's sort of like it is a passive way of sort of protesting.
He tohu tērā. He tohu. At the mana motuhake. It's our statement that this is ours and will remain ours.